My wife told me on a Thursday evening in late October, standing in the doorway of our kitchen in the house I had owned since I was 29 years old, that she needed someone who could exist in her world. She said it while her back was to me. She was looking at her own reflection in the dark window above the kitchen sink, straightening the collar of a blazer she had bought 3 weeks earlier at a boutique in the Gulch neighborhood of downtown Nashville. On a credit card I had added her to 7 years before. She had not eaten the dinner I made. She had come home from a partner's reception at the firm in Nashville where she had been working for 6 months, driven the 50 miles back to Knoxville at 10:15 at night, and stood in the doorway of our kitchen and told me she needed someone who could exist in her world. I want to tell you about the folder before I tell you anything else, because the folder is the reason I am telling you this story at all. But first, let me tell you who I am and how I ended up standing in my own kitchen on a Thursday evening in late October being told by my wife that I could not exist in her world. My name is Craig Sutter. I am 43 years old. I run a small electrical contracting company called Ridgeline Electric out of a warehouse space off Western Avenue on the north side of Knoxville, Tennessee. I have 14 employees, 12 of them are full-time. We do commercial and industrial electrical work, new construction, retrofit, service calls for facilities managers who have a panel problem at 2 in the morning and need someone who answers the phone. I have been a licensed electrician for 21 years. I have an associate's degree from Pellissippi State Community College in Knoxville that I completed in my early 20s while I was also getting my journeyman's license. I do not have a 4-year degree. I have never needed one to do what I do, which is to know more about how electricity moves through a building than most people in this country will ever know about anything. I met my wife Natalie at a fundraiser for the Knox County Literacy Council on a Friday evening in September, 6 years before the Thursday in October. She was 30 years old. She was working at the time as a senior paralegal at a firm called Brennan and Whitfield on Gay Street in downtown Knoxville, a mid-sized firm that handled commercial litigation and estate planning. She had been there for 5 years. She was the kind of paralegal, I would learn over the following months, that the attorneys at Brennan and Whitfield relied on the way that people rely on the one person in any organization who actually knows where everything is and why it matters. She was precise, she was organized, she noticed things. She also wanted, more than she wanted almost anything else she had ever wanted, to be an attorney. She told me this on our second date, a Saturday dinner at a place on Market Square I had been going to for years. She told me she had wanted to be a lawyer since she was 19 years old, when she had driven to Maryville to watch her Aunt Frances, who practiced family law there, represent a woman in a custody hearing who had no money and no options and walked out of that courtroom with her children. She told me she had applied to law school twice, once at 27, once at 29, and been rejected both times. Her LSAT scores were not, by her own clear-eyed accounting of her academic history, competitive enough. She was studying for a third attempt. She did not know, by the night of our dinner, whether she was going to score well enough to be admitted anywhere she could actually attend while staying in Knoxville. I asked her what score she needed to get into UT Law. She told me. I told her I thought she could do it. She laughed. She asked me if I said things like that to everyone. I told her I said things like that when I believed them. I told her I could not speak to her LSAT scores, but I could speak to the fact that a woman who had spent 5 years learning the interior of a litigation firm from the inside, who had driven to Maryville at 19 to watch a custody hearing because she wanted to understand what lawyers actually did, was not a woman who was going to fail at a thing she had decided to do. She looked at me for a moment across the table. She scored a 161 on her third attempt. She was admitted to the University of Tennessee College of Law in Knoxville on a partial merit scholarship that covered approximately 40% of her tuition. We had been dating for 14 months at the point of her admission. We were engaged by the time her first semester started. The remaining 60% of her tuition, combined with books, bar exam fees, the professional clothing she would need for clerkships, and the general financial strain of 3 years during which she moved from full-time employment to part-time consulting work, came to approximately $187,000 over 3 years. I paid it. I paid it from the operating reserves of Ridgeline Electric and from a personal savings account at Home Federal Savings Bank on Kingston Pike that I had been building since I was 24 years old. I want to tell you about the document. I want to tell you about it here before the Thursday evening in October and before the courtroom, because the document is the thing that makes everything that comes after it make sense. Natalie drafted it herself. She drafted it 2 months before her first semester, on a Sunday afternoon after we had come back from a weekend in Gatlinburg where we had talked, seriously and at length, about what the next 3 years were going to look like and what would happen to both of us if the marriage did not survive them. She did not sleep well the night after that conversation. She was up by 6 on the Sunday morning and made coffee and sat at the kitchen table with her laptop and typed something for about 40 minutes. She printed it on the printer in the spare room. She brought it into the living room where I was reading. She handed it to me without saying a word. She sat down across from me on the other end of the couch and watched me read it. The document was formatted the way she formatted everything she produced professionally at Brennan and Whitfield. Clean margins, a header, a reference line, a signature block. It looked like a memorandum. It was written like one, too, in language that was considerably more precise than I would have been able to produce on my own. It said that in the event our marriage ended by dissolution within 7 years of the date she passed the Tennessee bar examination, she would repay to me in full all documented educational expenses I had contributed on her behalf, with 5% annual interest calculated from the date each payment was made. It said she would not seek division of any assets of Ridgeline Electric or any business interest I held at the time of dissolution. It said she was not drafting a legally binding contract. She was careful to note that she was not yet an attorney and was not representing herself as drafting an enforceable legal instrument. She was writing a personal commitment. In writing, in the most serious form, she knew how to give a written statement, because she was on that Sunday morning the kind of woman who believed that the person willing to put his financial security behind her dream was the person she owed her most careful honesty to. She signed it at the bottom in her own handwriting. She printed her name beneath the signature. She dated it. I read it twice. I told her I did not need it. I told her the money was not a loan and had never been intended as a loan, and that I was not the kind of man who needed a written guarantee before he chose to believe in the person he was going to marry. She told me she knew that. She told me she was not writing it for me. She told me she was writing it for herself. She told me she had worked inside a litigation firm for 5 years, and that she had read enough discovery documents and deposition transcripts and contested asset schedules to know what people became capable of when they were afraid or uncertain or surrounded by other people who told them, day after day, that they deserved something they did not yet have. She told me she wanted the person sitting at the kitchen table on a Sunday morning in August to be able to speak, if it ever came to it, to any future version of herself who might start to believe that the man who made her possible was the man she needed to leave behind. I folded the document. I put it in the fireproof lockbox I keep in the closet of my home office alongside the deed to the house and the corporate formation documents for Ridgeline Electric. I kept it there for the next 3 years and 2 months. I did not show it to anyone. I did not tell my wife I still had it. The changing started by my best private accounting in the late fall of her second year of law school, when she began a clerkship 2 days a week at a corporate firm in Nashville called Hargrove Dean & Associates. The people at Hargrove Dean were not bad people, from what I could observe. They were people who had grown up in homes where law school was not an ambition but an expectation, where the dinner table conversation included case strategy and firm politics, where the measure of a person's professional life was calibrated in billable hours and the particular zip codes of their undergraduate institutions. Natalie started spending more evenings in Nashville after her clerkship days. She made friends among the associates at Hargrove Dean. She started attending firm events on weekend evenings, driving down on Saturday afternoons and returning late. She bought clothes for those events that were different from what she had worn before. Not extravagant, but unmistakably oriented toward a different register of life than the one we had been living. She started using language in our conversations at home that I recognized from the documents I signed when I incorporated Ridgeline Electric, but that I had never heard her use at our dinner table before. I am not a man who is unfamiliar with professional language. I have worked for hospitals and law firms and facility managers for 20 years. I know the vocabulary. What I noticed was not the words themselves. It was the way she used them, as a kind of placement, as a way of situating herself inside a world and, without quite saying so, situating me outside of it. I did not say anything about the changing for most of the year I watched it happen. I thought it was adjustment. I thought she was learning the language and culture of a new profession the way I had learned the codes and protocols of electrical work, by immersion, by repetition, by spending your days around people who already knew the territory. I told myself the distance I felt was the distance of 2 people in different professional seasons, not the distance of a woman who had made a private decision and had not yet told me about it. She passed the Tennessee bar on her first attempt. She accepted an associate position at Hargrove Dean in Nashville. She called me from the parking lot of the testing center to tell me I was at a job site in Oak Ridge. I heard something in her voice on that call that I had not heard in it before, not joy exactly, not relief, but something closer to the particular satisfaction of a person who has just had something confirmed about themselves that they had already privately decided was true. We had dinner that weekend to celebrate, a nicer restaurant than our usual. I ordered a bottle of wine I normally would not have ordered, and she talked about Nashville, about the apartment she was going to need to find, about the professional expectations of someone at a firm like Hargrove Dean. I listened. I thought we were making plans together. We were not planning the same future. The Thursday evening in late October, she came home from the partner's reception at 10:15. I had made dinner and left a plate for her in the oven the way I had done dozens of times during law school when she came home late from study groups or moot court practice. She did not eat it. She stood in the doorway of the kitchen and looked at her reflection in the dark window and told me she needed someone who could exist in her world. She said she had tried to imagine bringing me to firm events, to bar association dinners, to the professional gatherings that were going to constitute a central part of her life for the next 30 years, and that she could not construct that image in any way that felt real. She did not look at me when she said this. She told me her attorney, a man named David Thorne at a Nashville firm, had already filed a dissolution petition in Knox County Family Court. The petition was requesting an equitable division of the marital estate, including a 40% interest in Ridgeline Electric, which her attorney had valued at approximately $340,000. She said she thought she was being reasonable. She was not asking for alimony. She wanted a clean start. She picked up the overnight bag she had left by the door. She told me she was staying in Nashville and would be in touch through her attorney. She straightened her collar one final time. She left. I stood in the kitchen for a while after she left, long enough that the overhead light on its automatic timer clicked off and I was standing in the dark. I turned it back on. I ate the dinner I had made. I washed the dishes. I went to bed. I called my attorney Gene Holbrook on the Friday morning. Gene is 61 years old. He has a 2-attorney practice on Kingston Pike that has handled contract disputes, business formations, and contested divorces for the better part of 30 years. He did the incorporation paperwork for Ridgeline Electric 11 years ago. He is the kind of attorney who charges a fair rate and returns phone calls the same day, which are, in my experience, the two things that separate a reliable attorney from every other kind. I told him what happened Thursday evening. He asked me to come to his office. I sat down across from his desk and told him about the document. His expression did not change dramatically. It rarely does. He asked me where the document was. I told him it was in the lockbox at home. He told me to retrieve it, bring it to him, and not discuss it with anyone. I did exactly that. He called me the following Tuesday evening. He told me the document was not, under Tennessee law, a legally binding contract. But it was, in his professional reading of it, a clear and unambiguous written statement against the interest of the petitioner, drafted by the petitioner herself, in professional legal formatting, signed and dated by the petitioner, which any reasonable Knox County Family Court judge was going to take seriously when evaluating a claim for 40% of a business the respondent had built over 17 years before the marriage began. He told me to let him handle it. I let him handle it. The 5 weeks between that Tuesday and the morning of the hearing were quiet in the way that a job site is quiet in the hour before the crew arrives. Purposeful quiet, not empty quiet. I worked. I ran jobs in Oak Ridge and Maryville and a commercial build in Lenoir City where we were doing the electrical rough-in on a new medical clinic. I did the work the way I'd been doing the work since I was 22 years old, methodically, correctly, without drama. I thought about my wife. I thought about her at the fundraiser, the way she had laughed when I told her the audio system was wired incorrectly, and that was why the microphone kept cutting out, the way she had looked at me in that moment like I was someone worth noticing. I thought about her at the kitchen table on a Sunday morning, printing out a document that was her way of telling me, and herself, who she was choosing to be. I spent enough time in older buildings to know that the wiring that looks reliable from the outside can be compromised in ways that are not visible until something trips a breaker. I could not tell you exactly when the breaker tripped in my wife's case, or why, or who she was spending time with in those Nashville evenings that made the life we had built in Knoxville look insufficient to her. I decided somewhere on Interstate 40 between Knoxville and Nashville during one of those 5 weeks that it did not matter enough to spend more of my life trying to figure it out. What I knew was that the woman who had sat across from me on the couch and handed me a document she had formatted and typed and signed was not the woman who had stood in the kitchen doorway straightening her collar without looking at me. I knew which one had asked me to keep her honest. I was going to try to do that. It was the only thing I was still going to do. The hearing was on a Tuesday morning in the second week of December, in a wood-paneled courtroom on the 4th floor of the City-County building on Main Street in Knoxville. The judge was a woman named Ann Greer, who had been on the Knox County Family Court bench for 16 years and who had, by Gene's description of her, a reputation for being patient, precise, and entirely uninterested in being managed. I sat at the respondent's table with Gene to my left. My wife sat at the petitioner's table with David Thorne, her attorney, to her right. She was wearing a charcoal suit. She looked like what she was now, an attorney. She did not look at me when she walked in. She did not look at me during the bailiff's announcement. David Thorne presented the petition in the careful, measured voice of a man who believed the case in front of him was uncomplicated. When it was our turn, Jean stood and told Judge Greer that we would be entering a single item of documentary evidence into the record. He described it as a personal commitment letter, drafted by the petitioner prior to entering law school, signed and dated in the petitioner's own hand. He said it spoke for itself. He submitted it through the bailiff. Judge Greer received the document. She read it. She took her time. She is not, by Jean's account or by my own observation from the respondent's table, a woman who is rushed by other people's impatience. She read it twice. She looked at the signature at the bottom. She looked at the date. She looked at the paragraph concerning equitable division of business assets. Then she looked up. She looked at my wife at the petitioner's table. She said in a voice that was perfectly level and entirely without performance, "Mrs. Sutter, this document appears to have been formatted using a standard legal memorandum template. Did you draft this yourself?" David Thorne leaned toward my wife and said something I could not hear from 14 feet away. My wife said yes. Judge Greer looked at the document for a moment longer. She set it down on the bench in front of her. She folded her hands, she said with the measured clarity of a woman who has spent 16 years watching people underestimate the documents they put their names to. "Then you understand what it says." It was not a question. David Thorne requested a 30-minute recess. Judge Greer granted it. When court reconvened, David Thorne approached the bench and filed a motion to amend the petition. The amended petition did not include a request for interest in Ridgeline Electric. It did not include any claim on my business assets. It requested dissolution on grounds of irreconcilable differences, each party retaining their own separately held assets, no spousal support in either direction. Jean and I did not contest it. The divorce was finalized 6 weeks later. My wife relocated to Nashville. She is, from what I have heard from people who have mentioned her in passing, doing well at Hargrove Dean. I have not spoken to her since the morning of the hearing. I have not had reason to. The $187,000 I paid toward her law degree is money I do not expect to see again. Jean advised me that pursuing it separately through a breach claim would be a years-long process with uncertain outcomes. I thought about it for about a week. I decided that spending the next 3 years chasing money through a courtroom was not how I wanted to use the time I had left. Ridgeline Electric is doing fine. We picked up 2 new commercial contracts this past spring. I hired a new apprentice who reminds me, in his careful attention to doing things right the first time, of myself at 22. About 3 weeks ago, I was at a job site in Maryville at 6 in the morning, pulling wire in a new medical office building before the rest of the crew arrived. It was cold. The building was not yet heated. We had thermoses of coffee and a folding table set up in what would eventually be the waiting room. My foreman, Dennis Polk, who has worked with me for 9 years and who is the kind of man who says what he means and stops there, poured himself a cup of coffee and looked at me across the folding table and asked me how I was doing. I told him I was fine. He nodded. He drank his coffee. He did not ask anything else. We went back to work. That is the honest account of it. I am 43 years old. I own a small electrical company and a house on the north side of Knoxville and a set of tools I have been accumulating since I was apprentice age. I am not a man who attended law school or passed the bar or stood in a marble lobby in Nashville making small talk with firm partners. I am a man who knows how to trace a fault in a circuit back to its origin, who answers his phone at 2 in the morning when a facilities manager has a panel down, who kept a document in a fireproof box for 3 years because the woman who gave it to him asked him, in her own words, to keep her honest, and he intended to try. I did not win anything in that courtroom. I kept what was already mine. Those are not the same thing, and I think it matters to say so. Tell me in the comments about someone in your life who became a person you no longer recognized. Tell me when you first saw it happening. Tell me whether you ever figured out what changed, or whether you reached a point where that question stopped being the one that mattered. I read everyone.